following audio lecture can only be used with the express written permission of Rick Ramos or Contra Costa College. This is Professor Rick Ramos, and this is a continuation of Administration of Justice 122, Criminal Procedures. We're in Lecture 3, Part 2. We're going to be talking about contacts, consensual encounters, and detentions today. Make sure you're reading your textbook, because just listening to the lectures will not give you all the information you need to be able to successfully complete the tests associated with this course. The first thing that we need to define is what is a consensual encounter, because there's going to be three levels of contact you're going to make here with someone. You're going to have either a consensual encounter or a detention, or it's going to be an arrest. Consensual encounters and contacts can include contacts with victims or witnesses, shop owners, or residents with problems that are non-criminal, or tourists asking you for directions, or it can even come in the form of you contacting a stranded motorist. Consensual encounters are different than detentions or arrests because they do not involve the seizure of the person within the meaning of the Fourth Amendment. They usually involve a face-to-face encounter between the officer and an individual, where the individual is not obligated to answer any questions, they're free to leave, and they reasonably believe that they're free to leave. That's a very important point. Now, you can still ask someone for ID as long as they reasonably believe they're free to leave, and they can turn you down. But you got to be careful, because there is a case that came out of LAPD where the retention of the person's identification during an interview elevated the contact to a detention. If you take their ID and that induces a belief they cannot leave, you've elevated the situation to a detention. I always like to tell you about possible consequences, what can happen to you if you inadvertently elevate a contact into an unlawful detention. If a peace officer unreasonably restricts the movement of a private person or conveys the message to that subject that they're not free to leave when there is no specific reason to justify detention or arrest, the officer could be subject to criminal prosecution under Penal Code Section 236 for false imprisonment, suppression of evidence discovered using the exclusionary rule in a 1538 hearing, civil or criminal prosecution for violation of civil rights, and also you may end up with internal affairs complaint against you where you can be disciplined by your police department. That's not to say that all contacts where you question someone are going to subject you to some problems. All I'm saying is you need to be careful. So let's start to look at legal definitions of contacts when you're investigating cases. The legal definition of a consensual encounter is a voluntary exchange between an officer and a citizen with no restraint of personal liberty. Now, a consensual encounter may occur in the field as well as at the police station. If the subject voluntarily appears at the station and is willing to talk to you, then that's a consensual encounter. An example given by Ed Peoples in his text is that a 17-year-old was called in for an interview with Los Angeles police detectives. Then he was questioned for nearly 2 hours about his efforts to help a friend try to steal a truck, during which the truck driver was shot to death. The boy's parents brought him into the police station, waited in the lobby while the boy was questioned. The detective made no pretense of arresting or detaining the boy and acted as if it was a consensual encounter, even asking the boy if he wanted to take a break during the questioning. Well, this young man finally admitted to being involved in the shooting and ultimately was convicted of murder and robbery. On appeal, in a 5-4 decision, the U.S. Supreme Court upheld the conviction and the fact that the encounter was consensual. They ruled that the age and inexperience of the justice system are not a factor to be considered in that case, and they're not part of the Miranda issue. What they mean by that is if you're not under arrest, you don't have to deal with Miranda, which is telling someone about their Fifth and Sixth Amendment rights. Many students have questions about whether or not you could be subjected to a search while you are in a consensual contact mode, and the answer is, if you waive your Fourth Amendment right, an officer can search as long as you allow that search to occur. So those are called consensual searches, and if you're trying to get a consensual search out of someone, it should also always be done by asking permission. In other words, the question should allow the citizen to refuse by stating no, or allow them to allow you to search by stating yes. An example would be, do you mind if I search your car or your backpack or your person or your trunk? As long as they have the ability to say yes or no, then you're okay. And that would be considered a consent search. Now, we haven't got into my typology on how to conduct a detention and to elevate this situation toward an arrest yet. But the thing you need to know is that in California, there's a hearing called a 1538 hearing. And in that hearing, during your preliminary hearing, a judge is going to review whether or not that you performed was legal or not, and whether the evidence will be allowed in court or if it's going to be excluded using the exclusionary rule, which we've already spoken about. Officers who elevate a consensual encounter to a detention without reasonable suspicion may put themselves in a situation where the evidence is going to be excluded based upon that illegal detention. I'd like to remind you again in this lecture that the best way to learn, or the way that I teach, is you can listen to the lecture as many times as you want in a recorded mode, but you need to sit down at some point with lecture notes for part 3 and add, because I'm going to add much more than is going to be in the PowerPoint notes that you have and what the book is going to give you. Okay, the next topic is reasonable suspicion to detain. Now, my expertise in this area is that when I was a young professor at Santa Rosa College, where I had the opportunity to teach in the police academy, I was sent to a post matter experts meeting where we discussed the topic of reasonable detention and arrest. Everything that's in this LD-15 I originally helped post put together. One of the great minds that was there was DeValis Rutledge, who was a district attorney out of Orange County, and he wrote a lot of material that we're still referring to. Both Ed Peoples' book and what I have comes from a lot of what came out of that area. Now, a detention is a stop of a person for an investigative purpose. Officers use their authority to compel the person to halt, remain in one place, or to perform some sort of act. You have to have what's called individualized suspicion. In a case called United States versus Socolow in 1989, it says that a person is not free to leave and has the perception that he or she is not free to leave, but detention is only for the purpose of settling the issue raised by the suspicion of the officer. Now, a lot of my students have had a tough time in being able to understand when can I actually stop somebody. Well, some examples of detentions include traffic stops or field evaluations of persons suspected of driving under the influence of liquor, alcohol, or drugs, a field interview in response to a call or an observation. And in those situations, again, the person reasonably knows they cannot leave. And a detention doesn't exist until the person's detained. In other words, if I come up to you and say, I need to speak to you. Now, here's the difference. When it's a consensual encounter, when it's a consensual contact, I'm going to say, can I speak to you for a second? I really need to speak to you. And the person has the opportunity to say yes or no. But in a detention, I'm going to say, come here. I need to see you now. Come here. No, you don't have a choice. Come over here, I need to see some ID. Big difference. The demeanor of the officer changes, the voice inflection changes, but you need to make sure that you have it together as far as legally what you need. How do you stop people? When you turn your red light on, you're making a detention. When you have reasonable suspicion to detain. The other thing that might be is if you see somebody who's stumbling around, they look like they're going to walk into traffic, they might be intoxicated or, confused in a mental state. You have the ability to stop them to check to make sure that they're okay. A detention is warranted if the officer is in a place where they have a right to be, and if the officer can articulate specific facts as to why they've stopped somebody. So what that is that criminal activity has occurred, is occurring, or is about to occur, and the person detained is involved in that activity. Can't be a hunch. It must be an articulable fact. Now, I'm going to start to deviate from peace officer standards and training. And, when I talk about post, I mean peace officer standard and training in California and the minimal requirements for you to be a police officer, the knowledge base that you have to have. And when we talk about LDs, we're talking about learning domains. That's just basically how they've cataloged all the different student learning outcomes or things that you must learn. So here's how I teach this. You're going to learn some new terminology here. Reasonable suspicion, or the lowest level of grounds to detain. We're going to start calling that RS1. Reasonable suspicion, the next level up, where you have grounds to conduct a cursory search within the detention, and a cursory search is a limited pat search of the suspect's clothing for weapons. We're going to call that RS2. So you need to get used to those two terms because I'm going to use them. If you look at the slide that basically shows you the triangle, this is Ramos's typology of reasonable suspicion. I want it to be really simple. I want you to think about that triangle in your head, and you have 3 points on the triangle. The top one is crime or criminal activity is occurring, or has occurred, or is about to occur. Next is we have to focus on someone. We have to focus on an individual or a number of individuals. And the third thing is that there is a link, that suspicious activity that they are involved in is connected to the crime that we're dealing with. So as long as you have those 3 things, you've got it made. Now, the test of reasonable detention is what they call the reasonable officer test. When you are making an arrest, it's going to be the reasonable citizen test. Would a reasonable person in the same situation believe the person should be arrested? But when we're talking about detentions, the officer must objectively entertain the suspicion, and another reasonable officer in the same situation would have come to the same conclusion. That's basically the basis that they're going to use in court. Now, what are some factors that would allow you to detain someone? Besides that typology I gave you, if you think you have someone injured, they're a victim of a crime, then you have a responsibility to stop them. That's probably going to be more of a consensual encounter. But they could also be a suspect who's just shot. So anyhow, appearance could be a big thing. Do they look like they're intoxicated? Do they resemble a wanted person? Can't be based on race alone, by the way. Do they look like they're injured? Are you responding to a burglary alarm, silent alarm, and you see someone who's coming out the back of a warehouse, or they're carrying some tools, or they're looking in windows? Are they parked in an unusual spot? The other thing is actions, and new word, here we go. Consciousness of guilt. Consciousness of guilt is that guilty look someone gives you when they look like they just got caught. The cat got caught in the canary cage with the canary hanging out of their mouth. It's the look. It's something they say. When you pull your patrol car around the corner, are they trying to hide? Are they in the vicinity or proximity of a crime? And what I mean by that, you're going to hear the word contemporaneous. Contemporaneous simply means that you were in the area in the logical time the suspect would have been in the area right after the crime occurred. Do they throw something away? Are they trying to divest themselves of responsibility of someone just as they see you? Or are they running from the scene? So here's a great example. You're arriving to a call of a suspicious person who appears to be casing a building. They're looking inside windows. It's about 11:30 at night, so there's not a lot of people on the street. And you have a pretty good, a good description of the suspect. It's a white male, 6'2", red cap, red tennis shoes, white t-shirt, blue jeans. And you pull around the corner, you see the individual. And when you get out, they don't see you. You're real quiet, very stealthy. You're very quiet, and you kind of sneak up on them. And they're walking towards you, and they go, "Oh shit, the cops!" And they turn around, they do a 360 and start walking the opposite direction. That is consciousness of guilt. You heard them go, "Oh my God," they were surprised that they saw you. They believe they're going to be stopped, and in that situation, you can make a stop on them. Traffic violations are detentions. You're stopping people for erratic behavior, for committing a traffic violation, for equipment violations. It doesn't matter. There are a number of different reasons that we could stop somebody. There's a case called Sullivan versus Arkansas, U.S. Supreme Court 2001. It talks about pretext stops, and I'm going to talk about pretext stops really quickly. There's a couple of other cases also. One of the earliest ones was in 1996, is Wren versus U.S. And in this case, the officer stopped the suspect on what he said was a very minor traffic violation, when the officer's real purpose was to see to see who was in the car and to find out a way to obtain a consent search of the car. In that case, the Supreme Court said that it could be something as minor as a license plate light out. It doesn't matter. They don't really care what your motivation is, as long as you have the probable cause for the VC violation, the vehicle code violation, you can make the stop. There's a case that occurred where the officers were detectives. They were in an unmarked car. They're following the suspect around. They know he's a dope dealer. The person makes like a unsafe lane change, something really minor. They pull him over. When they pull him over, they eventually get a search of the car. And the argument from the suspect was, hey, these guys pulled me over. They weren't even in uniform. The guy didn't even have a ticket book to write me a ticket. But the court said it didn't matter. As long as they had probable cause to make the original stop, they were good to go. Other factors you can use is the prior knowledge of the person. Did you arrest the suspect before? You have a criminal history of this person? Are they known to have committed serious offenses before? Do they have a history of committing similar crimes as to the one that you're investigating? You can also look at what the suspect's demeanor is during the detention, but you can't just get an attitude on a person and make an arrest because of their attitude. But you need to record certain factors in your report, like, is the suspect responsive? Are they evasive to answers? Do they give you incriminating answers? Are they nervous? Are they belligerent? Are they too casual for the situation? Other factors we want to take into account are the time of day. This person's walking around in an area where during that time of the day or night, the crime is usually occurring. Is it unusual for people to be in that location at that particular time of the day? Also looking at area of the stop. Is it near location where a known offense was committed? Is it right after it was committed? Remember I talked about that word. Is it contemporaneous to when the crime was committed? Is it a high crime area? Can the suspect be connected to that type of criminal activity? Make sure you're very careful when you use the term high crime area in your report. Make sure you've done your homework. What that means is you need to go back and look at your police logs to determine what kinds of crimes have been occurring and whether or not you can justify making the stop. You better be able to articulate the type of crimes that are occurring, the frequency that they occur, location of occurrence, and how you obtain the information from either your personal investigations, talking to other officers about the case, or actually going into crime prevention and doing an analysis of the certain crimes that are occurring on your beat. Other factors that should be taken into account are modus operandi, which is the observable method of operation. If you have somebody using a crowbar to get into a building and you have a suspect walking with a crowbar around that area at late at night, that's going to give you the opportunity to make a stop. Sources of information are good. Do you get them from private persons? Are you getting them from informants? Are you getting them from confidential informants? It's important to be able to articulate where you're getting this information. If it's a tested informant, it means that they've proven accurate in the past, and you don't want to give them up because it's going to be put them in danger, right? Especially if people are telling you things that are against their penal interest. They're involved in the crime somehow, or you can independently corroborate them. Untested informants, though, must have corroboration, meaning that there's other information independently that you can gather that shows that they're more than likely telling the truth. Always know what the informant's motivation is. That's another factor that's important. Are they going to rat somebody out, revenge? What's going on? Again, the ultimate goal here is to put together the typology, the three corners of the triangle, and you can do it in a variety of ways. Because remember, dispatch is going to call you. They're going to give you information secondhand, and that's from citizen informants. You could do the same thing with your little tribe of informants that you're using on the street. The important thing to remember is to lay the groundwork in your report. Every officer who conducts a detention must articulate the facts about the original stop in the report to get the crime charged if it leads to, in that direction. We're now going to move on to compare consensual encounters with detentions. I want to talk about one situation. A recent Ohio case showed how an officer may use a traffic stop to move from a legal detention to a consensual encounter without the motorist being aware of the shift. That decision was Ohio versus Robinette in 1996. And basically, the cops stop Robinette for speeding, and they basically take care of their business with the citation, and they don't indicate to Robinette that he's free to leave, and the deputy asks him if he's carrying any illegal contraband or guns, etc., and he says no. And then he consented to a search of his car and they found a small amount of marijuana in a pill. He was arrested and charged, and his complaint in his appeal was that he didn't know he was free to go, and the Ohio Supreme Court basically said that the officer doesn't have the responsibility to tell you you're free to go. And later on, the Supreme Court of the U.S. held that if Ohio wants to have a law regulating its officers telling people that they're free to go, then they have to do that on independent state grounds, having a state law that makes that happen, and that it's not a constitutional issue. Now, that basically said that officers do not have to advise citizens that they're free to go. If they sit and continue to chat with them and they get a consensual search out of it, that's good to go as far as the court goes. Now, let's take it a step further. In 1998, a guy named Knowles gets pulled over in Iowa, and at the time, the Iowa law provides that an officer may cite a motorist instead of making an arrest for a citation, but the decision to cite rather than arrest doesn't affect the officer's authority to conduct an otherwise lawful search of a vehicle, meaning that if they pull you over, you're technically under arrest for that violation. They could search your vehicle. They don't find anything. They just go ahead and cite you. And so in this case, there's a guy named Knowles who is traveling 43 into 25, and after the officer searches his car, he found a bag of marijuana and a pot pipe under the driver's seat, and the officer admitted that he had no consent and no cause. In court, Knowles' motion to suppress the evidence as a Fourth Amendment violation was denied, and he was convicted. His conviction and the search practice of the police were upheld in the Iowa Supreme Court. However, the case was appealed to the U.S. Supreme Court. The tenor of that court's thinking was suggested during oral arguments on November 3rd, 1998, when one justice noted that the person who gets pulled over on a traffic stop and receives a ticket would hardly be prepared for such full-blown scrutiny. And another justice stated that it does seem an enormous amount of authority put in the hands of the police. So on December 14, 1998, the Supreme Court basically said that under Knowles versus Iowa, that there's no justification for an officer to conduct a search of a person or a car during a routine traffic stop and citation, and Knowles' conviction was overturned. Now, they did say, however, that an officer could still make a Terry pat-down, which we'll talk about in a little bit, and basically they still said that the Robinette type of consent search was allowable. So the next thing I want to talk about is length of detentions. How long can you hold somebody? If you're stopping them for a traffic ticket, you can check the vehicle over and give it actually a safety check, traffic safety check. Does headlights work, brake lights work, reverse light work, the windshield wipers, that sort of stuff, if you really wanted to do that. But what it says is that it's supposed to be long enough for you to be able to check out what's going on. Now, if you're making a stop on somebody on the street, not related to a traffic stop, then it's only enough time to determine if they are involved in the crime or they're involved in suspicious activity related to that crime or illegal activity. Once your reasonable suspicion has been satisfied, you have to cut them loose. You can check people for warrants, but you can't take any longer than it takes to take care of business. So if I'm stopping you as a suspicious person, it's reasonable for me to run a DMV check and a criminal history check. If you're being suspected of casing a building, looking into a building, and I should be responsible and check to see if you have that in your criminal history. Now, once I've written the citation, I can't just leave you there. Now, in Robinette, remember the case says I don't have to tell you you're free to leave. As long as I don't tell you that you have to stay. If you turn and say, thanks for the citation, I got to go. Can I speak to you for a minute? Not right now, officer. I got to leave. And the person leaves. That's it. So again, warrant checks. Got to be careful with that. There's a LA case. Officers detain a suspected drug dealer. He's in an alleyway. They make a stop on him. The computers are down, and they hold him there for 45 minutes. He takes his ID, and that is the key. He took the ID, held onto it for 45 minutes while he was waiting for the computers to come up. When the computers come up, there's a warrant for his arrest. They make the arrest. Pursuant to the arrest, they pat search him, and they find the drugs in his pocket. And the court basically upheld the warrant arrest, but threw out the drugs. That's what's going to happen. Now, what happens if we have a serious offense? Like, I'm going to give you an example of a case. I had a case at Berkeley PD where we had a rape, and the woman was slapped around, but she could identify the suspect, so she thought. It was in an area near the UC campus, but it was like 3 in the morning. There wasn't very much foot traffic, and the description was a black male, 5'10" to 6'2", 165 to 200 pounds, white t-shirt, a Giants coat, blue jeans, and a black baseball cap. Now, we had 5 suspects in the area. Can you believe that? At 3 in the morning, 5 suspects in the area. Nobody had the jacket on, but they all had black caps on and everything else matched. So how can you justify stopping all those people? Well, because it's a possibility that all of them are suspects. You've met the 3-prong test. Think about that. You've met RS1, that first level of detention, RS1. Now, what the court uses to determine how long you can hold that person, because, of course, the first person, I'm going to drive by and do a lineup with my victim, put him in the car, admonish him that just because the police have somebody stopped doesn't mean that this is the person that did it. Can you look at them, tell me if it is the person, if it isn't the person, or if you're not sure? Do that to the first person, that's going to take about 10 minutes. By the time we get to the 5th person, we may be at 45 minutes, 50 minutes. Well, the court you could justify this in front of the court because the court uses the seriousness of the offense and the scope of the investigation to determine what the time limit should be. So in that sort of a situation, because it's a serious crime, it's a rape, and you are doing a methodical investigation that's reasonable, they'll allow you to extend that time. One of the things we have to be careful about is if we put the person in our patrol car and we drive them around, we have a de facto arrest. So detention plus transport equals arrest, but not all movement equals arrest. And what I mean by that is you could be in a situation where you get permission, right? There's other reasons that you can take somebody. If the victim's incapacitated at the hospital, you can force the person to go to the hospital and be viewed by the victim. But if they waive their rights, hey, it's no big deal. So, quick review. Remember, detention is meant to provide a reasonable, brief, on-site or on-scene investigation. Detainee, again, cannot be moved unless they give you permission or the victim's too injured to be moved to the field show up, or if you have probable cause to make the arrest. There may be some other examples I can give you. Gallegos versus LAPD 2002. The officers moved the suspect. He's not given them ID. They have probable cause to arrest for failure to ID, but it's based on a domestic violence case, and that was found to be a legal arrest. Also, inherently dangerous environments. You have a DUI stop. You can't stop them on the freeway, so you get on your loudspeaker and you tell them to pull off into an area that's a little safer, maybe a safer spot for the field sobriety test. Or the environment is an officer safety hazard. You're outside of a bar, you're trying to detain someone, and a hostile crowd develops, and you have to move them. Now, that doesn't mean just because it's a high crime area that you could be moving people all over the place. It means that you have to articulate at that moment that there was a danger that you were dealing with. In Lecture 4, we'll really get in depth about Miranda, but right now I just want to tell you that as far as Miranda goes, you can ask somebody without Mirandizing them their name and their address and the explanation for their presence or their conduct at a certain area. Miranda doesn't apply because Miranda only applies when it is a custody matter and detentions are not considered custody. Where Miranda kicks in is where you say the magic words you're under arrest, or you're in a situation where there's arrest-like restraints. In a case called Beheeler, was basically guns are pointed at the suspect, they had them handcuffed, they have them back of the patrol car. You can use minimal amount of force to detain somebody, but once you know that they're free to go, you need to unhandcuff them. I wouldn't handcuff people unless you feel that you can articulate they're going to run, they're going to fight, something is up. You have a hinky feeling, they're pulling away from you, they're not going along with the program, they won't let you pat search them, that sort of stuff. If you're in that level, we haven't got there yet. We will get there. A person detained without restraint is not in custody according to People versus Lopez. So again, if they're detained, you can talk to them without having to worry about giving them the Miranda warning. The things, again, you need to be careful of: you should avoid using handcuffs or guns during a detention situation wherever possible, unless it's an officer safety issue, obviously. When a detention exceeds the boundaries of a permissible stop, it can become a de facto arrest. And in your notes, I give you a couple of case citations here. Officers place handcuffs on a suspect known not to be armed for your safety in mind, even though the suspect seemed to agree. The court ruled it was excessive force and turned a valid detention into an invalid arrest. This was in Campbell, 1981 case. So you need to be really careful and be able to show it's something that needs to be done. Here's some examples where handcuffing did not elevate it to an arrest. Suspect known to be armed and police dog used to bite and hold. High risk situation, gang fight, single officer, prone control to cuffing, secured in back of the vehicle, the shorter period of time such extreme measures are used, the better. But in that case, Orozco, it was found to be okay. After chasing and wrestling a suspect to the ground, the officers handcuffed him, and it was determined not to be an arrest. Officers handcuffed a suspected purse snatcher to a guardrail and waited 25 minutes for the victim. That was in 87. That was a Bowen case. That also was not considered an arrest. Now, a refusal to cooperate by the person is not enough to make an arrest itself, but it might be enough to help you develop probable cause down the road, so just be aware of that. Flight from detention. If the person runs from you, in California we use PC 148, evading arrest. We can use that misdemeanor section because it occurs in our presence. I've already talked about use of force. You can use a minimal amount of force to compel a person to remain at the stop without losing the detention status, handcuffing them, putting them in the car. If the person is unruly, if they may fight, if they've already fled, you can't use deadly force to detain unless the officer is attacked by the suspect. If someone tells you, hey man, either arrest me or let me go, doesn't matter. They still have to stay, and that might be something that you're going to have to articulate and report with regard to being able to handcuff them if you think they're going to fight you. So one more time on warrant checks. You can't stop someone for the sole purpose of checking them for a warrant. If you have a suspect who's on the street and you know his name at the beginning of the shift, here's the thing I would always do. This is really good beat practice. Before you hit the street, go into the warrant bureau and look at all the new warrants that came out during the day. Kind of just walk through them. They're usually in alphabetical order, and look for suspects that you normally stop on your beat. You already have knowledge that they have warrants out for them. Boom, you got them. You could stop them. Again, you're only allowed the time it takes to resolve the reason for the stop to run a warrant check, a traffic citation, or detaining a suspicious person. If the computers are slow, you got to cut them loose. Something else you need to know, that under a 1997 case, Maryland versus Wilson, the court found that officers may order the driver and any passenger out of their car until the detention is complete. With respect to searches during traffic stops, you need to know the following. The Carroll case basically says that if you have probable cause to believe that there's evidence in the vehicle, if it's not in the front of the vehicle, you got probable cause to believe it's in the trunk, you can go in the trunk. But normally you can't do that. Normally when you make the arrest of a suspect at a traffic stop, you have the Chamel case, which basically says that you have arm's reach rule, including the interior of the vehicle. You have the Belted case that says you can search containers pursuant to arrest. There are some other cases I'm just going to read about, but these cases change all the time, and by the time you read this, it could have changed. Wyoming versus Houghton in 1999, basically an officer made a stop on a car, saw that a suspect had a syringe hanging out of his pocket, big dummy, makes an arrest on him, and then searches a purse that's in the vehicle belonging to a female passenger. He basically says that, he has a right to search anything in the vehicle. And drug paraphernalia is found in the purse, and she's arrested on a felony charge. At trial, she moves to suppress it, saying that the evidence is fruits of the poisonous tree, basically unlawful search of the passenger's property. The trial court denied her motion. She was convicted. However, the Wyoming Supreme Court reversed her conviction, saying the officer knew or should have known it was her property, and there was no reasonable cause to believe her of criminal activity. Her property was outside the scope of any legal search. On appeal, the U.S. Supreme Court reversed and held that an officer had probable cause to search the vehicle for contraband. The officer may search any containers capable of containing contraband, regardless of whose property it is. The end result at this time is that you could still search any container in the vehicle upon arrest of the other suspect. We know a lot of times that suspects will give weapons, drugs to their female counterpart so that she can hide it because officers are less likely to search them. The last topic for this lecture is about sobriety, border, and informational checkpoints. Now, basically, the Fourth Amendment prohibits police from having things like roadblocks, but you can have checkpoints for specific enforcement purposes like sobriety checkpoints, border checkpoints, and recently international checkpoints. The Supreme Court has basically said that they will allow limited uses of these checkpoints. Now, while the Supreme Court believes that roadblocks are indeed a violation of the Fourth Amendment, they found that there were 3 exceptions. And the first exception had to do with setting up sobriety checkpoints. The Supreme Court decided that for drunk driving checkpoints, sobriety checkpoints, that no one can seriously dispute the magnitude of the drunk driving problem or the state's interest in eradicating it. And that the measure of intrusion on the motorist is brief. You just stop they come up, you smell their breath, check their ID, and let them go. Called Michigan Department of State Police versus Stitz. The second exception they cited was inspections at our international borders by our Border Patrol. Routine stopping of vehicles at a permanent checkpoint on major thoroughfares. Again, the issue was whether the stops in questioning in the absence of any individualized suspicion, RS1, that a particular vehicle contains illegal aliens violated the Fourth Amendment, and basically said that while the need to make routine checkpoint stops is great, the consequent intrusion on Fourth Amendment interest is quite limited, so therefore they have allowed it. The third exception was allowed in 2004 in a case in Illinois versus a suspect named Lidster. And this one was to set up checkpoints to obtain information from motorists about a hit-and-run accident that occurred about a week before. And Lidster approached in his minivan and he was swerving. It turns out he was drunk. And so he basically was convicted and challenged his arrest and conviction, saying that it violated the Fourth Amendment for the checkpoint. And the court reasoned that the individualized suspicion was not needed in this case because the stop's primary law enforcement purpose was not to determine whether their vehicle's occupants were committing a crime, but to ask the occupants as members of the public for help in providing information about the crime, in all likelihood committed by others. So there was no Fourth Amendment issue. Okay, that's going to be the end of this lecture. In the next lecture, we're going to get into RS2, the second level of detention, and how you can justify pad searches.